90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau. Welcome to our employment law update for 2024 here on Law You Should Know. Our special guest is Eric Sarver, and he's the principal of the Sarver Law Firm with offices in Manhattan. Eric, thank you for coming to Law You Should Know.
Thanks for having me on the show, Ken. It's great to be here.
2024 is going to be a very important year for employers and especially for employees. So what are some of the things that are going to change, going to be very important to both employers and employees in 2024?
Right. It's a great question, Ken. Well, there are a few things that both sides, employers and employees, should keep in mind for 2024. I think one of the major issues we're seeing is that many states are banning non-compete agreements. Either they're banning them wholesale, full force, like such as California, and now New York is planning a ban as well. Or other states you might find are imposing minimum salary thresholds in order to enforce a non-compete agreement. So I think employers need to really keep their eye on what's happening in the news related to non-competes. And I think employers need to know if their non-competes are valid.
And it could be the most minor position, someone working at a basic wage for a store or a business or an entity. And when they want to leave, or if they take another job, they may be working for the competition because that's where the skill set is. They may be challenged. They may be sued.
Well, it's interesting, Ken, because I know what you're saying there. And a lot of non-competes, if the position that they're for is too low down on the totem pole, the theory is that that person doesn't really have the goods, so to speak, the trade secrets or the confidential proprietary information that one might need to do harm to the company. I give a very quick example. If you're the chief marketing officer at McDonald's, you might have a non-compete. You know where the secret sauce is, literally. But if you are the window drive-through person or the night shift supervisor, McDonald's cannot say that you can't work at Burger King because you're too low down on the totem pole. So I think the position you're in, along with how much you're making, those are all factors to consider.
And it's also common to have those type of agreements in professional partnerships, be they law or accounting or medical. And sometimes people want the same person they're comfortable with, even if they've left the firm. And that there shouldn't be an impingement on their ability to choose their professional from the client's perspective.
Absolutely right, yes. And you're right that they are non-competes often are used with professionals, with partnerships and partners and firms. And yes, clients, I think, want to also know that if they are going to a certain firm, that partner then can't break off and take clients with them. I think it gives partners peace of mind to have a non-compete in place. And different states have different rules about that. New York State's non-compete ban was getting very broad and saying even partners can be banned from having them. And there was pushback. So now we're seeing some changes to the law.
And also really the client controls. If the client wants to go to a dentist or a lawyer or an accountant, no one can stop the client from that freedom of choice.
Well, that's true. They can't stop the client. Usually what happens is, let's say an accountant or a lawyer has a non-compete, the client may be able to leave that firm, but the firm can get like an injunction in court to stop somebody from breaching the non-compete, from taking clients. But then there comes the question of, as you mentioned, client's freedom of choice. If you're a lawyer and you tell your client, hey, I'm leaving this big firm, starting my own practice, the client does not force to stay with the old firm. So this is where there's a tension. There's a tension in the law between the client's freedom and rights and the firm's ability to protect itself from unfair trade and from some secrets being exchanged and things of that nature.
But if you're a client, you can and should assert your rights and let the chips fall where they may.
Sure, I agree with that. Absolutely.
And so let's also talk about our transition to a remote or hybrid workforce. So companies are now transitioning into after COVID and perhaps keeping the idea of a remote or hybrid workforce to some extent. They're working out the fine points with their workers at various levels. So what are some of the issues there, and how might they play out?
It's a good question. And this answer to this question goes to your last question about what's changing in 2024. You mentioned non-competes, but also the remote workforce is certainly a big change. I think some major issues you see now with the remote workforce include, well, first off, there are new laws around like wages, for example. There are different wage laws in different states around when you need to give overtime and when you don't. And those laws may be different from state to state. Same with minimum wage. You might have a different minimum wage for your workers if you hire, let's say, an employee remotely in Idaho versus New York. Number two, we're seeing changes in terms of different laws around salary transparency. So if you're a company, Ken, and you're posting a job position, let's say in Colorado or New York, you have to list the salary range and the salary for that position. So I think that's another thing we're seeing with remote work. People are posting in other states not realizing that there's a law that says you have to state the salary. And the last thing I'll say is we're seeing changes in terms of different states have different laws around paid leave. Some states give maternity leave, some don't. Some have certain leave for voting. So essentially, you have to look at the state's laws around sick time and wages to determine if you are compliant with those different states that your employees might be in.
And there also might be different laws against discrimination. There might be local laws that go further than national or state laws.
Yep, absolutely. Some states, some cities have laws that go further in terms of protecting LGBTQ community and trans folks. And I think that it's really important to know that. There's also different standards. For example, what qualifies as a disability under a New York City human rights law is very broad compared to the federal level. Absolutely, yeah.
And let's go back to salary for a moment. If some part of the company is located in New York or the worker is located in New York, do those salary laws apply based on where the company's located, where the worker's located, or either?
You're referring to the salary transparency law?
Yes, yes.
Yes, absolutely. So it varies kind of from state to state. Most states will say it depends upon where the employee is located and working. Other states, like for example in New York, they did a little reversal. They started out saying it depends upon where the worker can do the work from. And then they went to say, well, now they're revising it in New York to say that it based also on where the company is located. So it varies from state to state, but usually it's either where the worker can do the work from, or where the worker is located, or where the company is located.
And the salary is sort of usually given as a range, and can the employee insist they get something within that range, or it's just a suggestion or a goal for the employer that they're not bound by?
It's a great question too. Yeah, so it's the employer, they're not so much bound to give that number within the range, but if their, let's say, range is way off, it has to be a good faith range, right? So if they're saying that they're paying $80,000 for a position and they pay somebody $50,000, that's a very broad difference. And one could argue that they didn't, in good faith, post that salary range. Now, they would not give the worker the right to that money, but it can open up the company to penalties and fines from the state. So what I'd say is, in that regard, right, companies should know the rate and the range for a position, and they should post accordingly.
And it may depend on the responsibilities, the billables, other things, and in the final analysis, that could change. Maybe the candidate who's hired doesn't have that experience, the minimum experience, or they're not bringing as much business, so their salary might be adjusted accordingly. Right.
I have clients right now, small business owners out there in Long Island and New York and I think different parts of the state, who are facing this very challenge because they had someone come on and either the person wanted more remote flex time and they said, okay, we'll give you these benefits, these perks. You can work more remotely, take more time off, more PTO. We're going to lower the salary, and they're actually right at the bottom of the range. So my advice is to give a range that's reasonable, but leaves you as the employer with enough flexibility that if you have to come in below what the range is posted for the job, right, you're still in a certain cushion that you're not going to be accused of bad faith when you post a salary for that position.
And also when you post, it could start a rebellion in the ranks. If other people feel they're not paid in that range, they should be paid more, or maybe they feel they're being discriminated against. So it can be problematic.
Ken, there's an irony there, what you just said. The ironic part is that the law, I think, was initially intended to supposed to be to curb discrimination, to close the gender and race pay gaps, which is a noble policy, a noble motivation for the policy. I think the problem often is that, like you'll see, as you mentioned, sometimes somebody is being paid now higher because the salary is on full display, and somebody in the ranks who's working there 5 years says, "How come I'm not getting that higher salary?" And then is the company forced to raise that person's pay? And does that person say, "I'm not getting paid this because I'm Chinese American or because I'm Jewish or because," so the person might substitute in their own mind what they think the reason is for not getting paid more. So you're seeing actually could cause.
So what are some legitimate reasons for paying different salaries to different folk? Is it because of their client base, their potential, their educational credentials, their billables, their track record?
I'd say all the above, right? I'd say choice F, all the above there, right? Exactly. Their performance, their experience, their education, what positions they've had before. What's interesting is that a lot of states like New York and other states are precluding employers from asking about prior salary and are preventing workers from talking about like certain issues around salary. So, but you'll find that, to your point, yes, you can actually pay somebody more, pay someone less based on their experience level, education, and what they're capable of doing.
And on the salary disclosure, I know some companies have in their code of conduct and their internal rules that you cannot discuss or disclose salary. So are all those rules out the window?
Not necessarily. It's interesting, right? Because some of those rules have to do with salary discussions in the workplace, but not necessarily about a new position being advertised, right? So it might be two existing positions, Mary in accounting and Jill, let's say, in bookkeeping, talking about how much do you make? How much do I make? And even those rules are being challenged sometimes because sometimes workers discuss the salaries because they want to organize, let's say, a protest about unfair wages. And that is protected activity under the National Labor Relations Act. So what I find as an employment lawyer, my job is to counsel my clients about like, hey, you have a policy in your handbook. Well, this might violate this law, right? And it might not violate this other law over here. So how do we like reconcile those two discrepancies?
And I just want to remind our listeners, we're talking with Eric Sarver. He's the principal of the Sarver Law Firm. We're talking about employment law update for 2024. You're listening to 90.3 WHPC. And if you miss any portion of the show, please don't hesitate to go to the podcast. And whatever you've heard is information only, and you should get legal advice, whether you're an employer or an employee, from your own professional. And so what are some other issues that are coming up as return? And can you pay differently if someone is making the commute, you need them physically in the office, versus someone who's working from home? Can you recognize the hardship involved in travel?
Ken, it's so funny, like in employment law, funny that so many questions have an "it depends" answer, right? You can pay someone differently. You can pay more, let's say, if somebody's coming into the job. But be careful in the following scenario. Let's say an employee is disabled and they can do their job, but they just can't get to and from the office because of the mobility issues. If their remote work is a reasonable accommodation request under the Americans with Disabilities Act, then if you pay less, it could be seen or viewed as discrimination, right? Yeah, you're discriminating in terms of unequal pay and salary based on my disability, right? So the short answer is yes, you can, but with caveats. I always tell my company clients, you're going to pay less or pay more for remote workers as long as they're not remote as a reasonable accommodation to a disability or a pregnancy, because there you can get into trouble. Like, hey, these are unequal terms and conditions of employment affecting me disparately as a disabled person, if that makes sense. Right?
And reasonable accommodation for disabilities is a big topic, and it's required under federal and state and local laws?
Correct. That's right. Absolutely.
So what type of disabilities can an employer be expected to accommodate for? And what are the limits? What are the minimums and what are the limits on what they need to do?
Sure. Right. Good question. Well, the range of disabilities is quite broad, really, as long as the condition, the medical or physical or psychological impairment is such that under the federal law, it has to substantially impede life activities. Basically, how are you able to get along in the world? That's how they define disability often. It could be permanent, it could be long-term. That's the federal law. It's the ADA, right? The state laws and the city laws are usually much broader definitions. Like some might say a medical condition. Like, for example, you could have a heart condition that you're still walking around, you're still driving, you can even maybe go to the gym. But if you have to constantly take medication and monitor it, if it affects and impacts your life, that could be considered disability. So the employer has to accommodate really anything that's in that category. And the employer can ask, hey, give me a doctor's note, right? Provide medical documentation. So that's like how it works. The employee says they're disabled, they get medical proof, and the employer can either say, okay, this accommodation request is not going to break the bank or be logistically impossible, so it's reasonable. We're going to grant this reasonable accommodation request. Or the employer can say, this is an unreasonable hardship it'll impose on us, and then can deny it or offer an alternative accommodation.
On a slightly different issue, can an employer require a certain standard of spoken or written English for her job?
Let's
say it's certain communication skills. You're handling customers. You want them to be understood and you to understand them. So does that come into play, or that's something that employers cannot discriminate about?
This actually happened to a client of mine, a small company, where the person that was a poor communicator, the company mentioned it, and the person said to them, I think this is because of my, right, English is my second language, right? I'm originally, Spanish, and I think you're discriminating against me because of my, my Spanish origins. So what I would say there is, you can certainly have those qualification requirements. If you have a salesperson and people can't understand what they're saying, that's problematic, right? It's a performance issue. But make sure as the employer that you choose your wording carefully. So you don't want to say, hey, I need someone that speaks better English, right? Or I need English as a primary language person. You want to say somebody with good communication skills, right? And that's a broader topic because you can be from another country and have fantastic communication skills with an accent, or you could be someone that was born in Brooklyn, and lived in America and has terrible communication skills. So I say put the focus on that they need clear and concise language, clear communication as a qualification, and not focusing so much on the English as the first language. That's when you get into trouble in terms of possible discrimination cases.
Are there other new anti-discrimination laws that are coming on the books of New York City or bans on discrimination that are going to be subject to interpretation or employers have to be concerned about implementing in 2024?
Actually, they sure will. That's a good question there too, Ken. You really have all the on-point questions here. I appreciate it. It gets to talk about these issues. So in New York City, for example, there's now going to be a height and weight discrimination ban in place. This is the first we've seen of this. Some cities are copying this as well, that you can't discriminate against the person in terms of promotions, advancement, or treatment based on their height or their physical size or weight. The weight one has exceptions if the weight is key to their job performance. So if somebody who, is very morbidly obese and weighs 380 pounds and they're 5'6" and they want to become a firefighter, right? Like that might, pose like a danger to them and others if they can't get in and out of a fire safely or climb up 4 flights of stairs. So in that sense, but the point is that's one category. Another category of discrimination, a larger enhancement of class protection to watch out for, or to be aware of, I should say, includes like certain transgendered people and people who might choose artificial insemination, artificial inception, say for child bearing, if that can't be the basis to discriminate against someone, you can't say, well, you don't get time off, let's say, to take care of your child compared to someone that had them naturally. So you can't not hire someone for that reason. And
you really can't even ask people about many of these issues that you've talked about, certainly in a job interview.
Absolutely.
And even if they're working for you, you really can't ask them about these things.
Right, exactly. You really can't, ask about sexual preferences, orientation, right, or religion. And there are reasons for that too. I think the law is concerned that if employers start to ask people those questions, for example, in a job interview, and they don't hire them, who's to say that wasn't maybe the motivating factor? I think employers protect themselves when they don't know the answers to these questions. They insulate themselves further from allegations of discrimination from the employee.
And even though it was unintentional, I'm sure you counsel your employer clients things they can and things they cannot ask at a job interview?
Oh, absolutely. Yes. I give those explanations, and I definitely counsel my clients about that all the time. Sometimes employers want to make small talk, so they ask someone, what's your favorite drink? Do you drink? Are you a drinker? And they're shocked when I tell them they shouldn't ask that question. They say, well, why not? It's a social issue. I say, well, if, say, your employer is a recovering alcoholic or substance abuse disorder, recovering drug addict, let's say, you're asking that question might reveal that status. So they come back and say, well, I'm sober 20 years, alcoholic in recovery. Then if you don't hire them or don't give them promotion, they might say, oh, this is based on my alcoholism, my recovery, So I always tell people, just to keep the questions a little more neutral. It's tricky, but don't talk about religion, disability, things of that nature.
I just want to remind our listeners, we're talking with Eric Sarver. He's the head of the Sarver Law Firm with offices in Manhattan, and he counsels mostly employers on employment law issues. And if you missed any part of the show, please don't hesitate to go to the podcast here on WHPC at nccradio.org. Are there other things that they really can't ask about? Are there things they can ask about once they hire someone and make an offer to them? Let's say a drug test, a background check, maybe a physical test if the work involves physical requirements?
Right. Sure. Actually, those are all three good examples of, yes, what some things an employer, like a business owner, can ask when they get past the interviewing stage. So, for example, if you work in a protected, regulated finance industry and the person passes the interview, now there might be a background check in place. It has to be relevant, of course, to the job that the person is performing. But yes, you can certainly ask, now that you've gotten through the interview stage, you're getting ready in the preliminary hiring phase, or once you hire them, to say, okay, now it's time we do. And even drug tests are becoming a tricky topic because certain drugs now are legal, right? Marijuana, for example, in many states is legalized, recreational and otherwise. So some states are now banning testing for that specific substance because it's on the same level as alcohol, right? Or nicotine, it's legal. So, but you can certainly test for unlawful drugs, like harder drugs that might impair someone's ability to do a job. So that's certainly an issue that comes up. Mm-hmm.
Let's say someone is hired and, sometimes issues come up in life. They have to take time off medically for themselves to care for a parent, care for a child or a relative. If you're flexible in accommodating one person, saying you can take that afternoon off or just, make up the work another day or don't worry about it, do you have to provide the same flexibility to all employees and can they claim some type of discrimination if you don't?
Well, so that's a great question because I defend litigation for employers too. I do compliance counseling, also defense work. And some of the cases I've defended over the years were just that. An employer said, how come you gave Susan, right, this accommodation? You gave Bob 6 weeks off because he hurt his back, but when I wanted to take off because I have a young child, I wanted to do the same remote work, you said no. So really, as an employer, you look at it and say, are you treating people in a protected class, like based on their race, religion, their having a child, the same in terms of accommodations, in terms of time off, for example, as your other employees. You do have to provide certain, let's say, flexibility, for example, for paid time off under the law, but it doesn't have to be identical, right, for every single worker, because it's really about like equal treatment more than identical treatment. There's a little bit of a nuanced difference there.
So can I sum it up this way? You can be mean to everyone and you won't get in trouble, but you can't pick and choose who you're nice to?
I would sort of slight tweaking that, but I'd say that you can be mean, an equal opportunity jerk, so to speak, right? As long as you're not being mean based on the person's protected class. So if you're being equally mean to, every foreign employee of yours because of their national origin, and then you're being mean to every U.S.-born employee because these three are women and these three are gay. So if you're just mean to everyone for non-protected reasons, then that's legal. That's unfortunate, but it's legal, yes.
And just summarize those protected reasons again. You want to be very careful not to discriminate against the protected classes.
And by the way, I will. And I also say, when you say being mean, in quotes, right, I'll say mean could rise to the level of harassment or a toxic workplace, which could be grounds for constructive discharge claims. So.
And I just meant failing to accommodate. I didn't mean it in any other sense.
Sure.
Just give us your website again, Eric, where I know you have many other valuable information available to our listeners.
Sure. So my website is www.sarverlaw.com, S like in Sam, A-R, V as in Victor, E-R, -law.com. And I help clients, like I said, with following the laws, defending lawsuits, or drafting employment contracts and doing business law as well.
And you have some of your other podcasts on that site?
I do, yes. I have a weekly podcast. It was on hiatus. I'm actually bringing it back now. It's called Employment Law Today. It was formerly on Talk Radio NYC, which is a fine station, but now I'm doing it on my own on a separate, independent, free platform. I have my own choosing, right? So I have more flexibility. And that's coming back probably in the next 3 weeks or so. We've got guests lined up to talk about these hot employment issues.
And what final thoughts do you have, advice for workers or for employers for 2024?
In this ever-changing world of remote work and hybrid work, and with employment labor law constantly changing, it's really important to get professional counseling and guidance when you hire, fire, or otherwise change up your employment situation. So my advice would quickly be, don't rely on Google, right? Google's not an attorney, to answer questions about employees, and don't rely simply on some online template you may have found for a commission agreement or a contract, because the law is always changing.
And if an employee has a concern or an employer has a concern with an employee, is it good to just communicate a little bit?
Absolutely, Ken. That's a great point. I've seen so many cases of litigation, whether it's the federal court, state court, EEOC, and so many of these issues or lawsuits came out of just a failure to communicate and a failure to listen to and hear the employee's concerns, which then fosters resentment. And the resentment just grows and grows and gets bigger and bigger until they end up taking a very harsh action, such as filing a lawsuit or hiring counsel to negotiate some sort of severance payout. So I think communication is a very key instrumental tool for employers to use with their employees.
And by the same token, a little consultation to understand the employer, to understand their rights and responsibilities can go a long way in preventing lawsuits and resolving problems.
That's right. Yes, absolutely agree with that 100%.
I'd like to thank Eric Sarver, as you've heard, is an employment lawyer with offices in Manhattan, for being our guest on Law You Should Know. Please keep in mind whatever you have heard is legal information and not intended to be advice about the law for employees or employers. And please, if you have any questions, listen to the podcast again and join us next week at this same time for another program on Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York.